So we also were massaged.
But is it not the same Western North form that was certified in the form by Rojo Metonunu?
That form was certified.
By who?
Of course, by Rojo Metonunu.
Thank you.
But, my lords, after certifying that form, he then drew the attention of Mr. Sribwo, who was working with us in the coalition room, that we have complained from our representative in that region, and therefore he signed in error.
Fantastic. Now, you are well aware that by all these forms that we have gone through for the court, you either sign or you indicate refuse to sign on the forms. You are well aware?
Yes, my lord.
You are well aware that failure or refusal to sign or just leaving the form blank was not an option. You are well aware?
My lord, in the strong room, our understanding was that we were there to make sure that ultimately whatever is declared as the outcome of the election reflects the will of the people. Therefore, we
are well aware.
Therefore,
Mr. White, please,
my lord,
answer the question. If you go about it, who doesn't know that the strong room is for you to go through whatever has been submitted and certified? Be allowed to give a lecture before he answers your question.
Right, you answer, and then if you have a response.
Thank you, my lords.
You are well aware that simply refusing to sign or indicate reasons or leaving the form blank was not an option for the purposes of the regulations that govern this election. That's what I'm asking you.
My lord, we are well aware.
Thank you.
But this is why the reasons were not stated. We had been asked by the Electoral Commissioner, when we brought our concerns to her attention, to go and have a deliberation with the petitioner. If she had allowed us to come back and she was still not convinced, we would have duly indicated those reasons there and allowed the process to continue. As it were, the process was truncated.
I have put it to you that you were not instructed by the chairperson of the first respondent to leave the room.
My lords, we were instructed by the first respondent. I had no reason whatsoever to just lie or deceive these honorable courts if that was not the case. And as I had indicated, our living there was not in secret. We openly told almost everybody who was there that based on our discussions with the first respondents, this is what the outcome is, and that we were going to be back. The reason for which we left everything we had at the place.
I am putting it to you that what you have just stated is false. And I'm further putting it to you that if it were true, well, my Lord, I'm grateful.
The question. Yeah. So allow the witness to answer the question.
Now, I am putting it to you that the EC chair did not instruct you to leave the strong room.
My lords, I maintain that we have no reason for leaving the place. Indeed,
I am.
Yes, she did instructed us to leave. And my lords, on this Saturday after the declaration, I believe an official of the EC has said in public that he had seen Mr. Rojo Metonunu gone to the Electoral Commission chairperson once we were there. Of course, this official may not be privy to what he discussed, but I can say and maintain that it is on the basis of her instruction that we exited the place.
I am further putting it to you that if what you were saying had any iota of truth, you would have provided at least one wee bit of corroborative evidence. I'm putting it to you.
My lords, the evidence is the fact that in leaving the place, we left everything we were working with. In leaving the place, we informed everybody else in the room, in the open conversation, that we were leaving the place and we will be back. Indeed, in leaving the place, we had no reason to believe that the chairperson of the EC was deceiving us and that was going to announce the results before we returned. But beyond that, my lords, at the time we were leaving, we had not come anywhere close to even knowing who had won and who had lost. The reason being that we were in the process of looking at region by region by region before we could move on to Form 13. As it were, and as it is now, we have never been presented with Form 13. We have never seen Form 13. We have never had the opportunity to actually have all the candidates and their results listed on Form 13 for us to vet again. The entire process was truncated. We were there to make sure that we had this thing done to the end. The only reason we left was because the first respondent had asked us to do so, and we did so in good faith. We did so in good faith in the interest of our democracy.
You see, on that day, you never spoke with the chair of the EC, did you? Yourself, you personally, you never spoke with her.
My lords, we were there working as a team.
Please answer the question. I'm saying you.
I, as an individual.
Yes. You didn't speak with her.
I did not speak to the EC chairperson personally.
Thank you. Thank you. Now, do you know why the forms had signed, or if you refuse to sign, indicate a reason? Do you know why? Do you know?
I don't know.
You don't know? Well, let me tell you what it is. The reason is that if there are irregularities, signing or indicating the reasons on the form, it will go to the next upper level and it will come to the notice of the EC officials there for resolution. I'm putting it to you.
My lords, as far as we were concerned, we were not given the opportunity to exhaust the processes that we were undertaking in order for us to come to a conclusion that our issues were not resolved, and therefore we were going to list them on the form.
Now, I am also putting it to you that the forms as endorsed is countersigned by the officials, and this becomes a certified complaint if indeed there are complaints on it. I'm putting it to you.
My lords, could you please take the question again?
I am saying that once you had earlier on agreed that if you indicate a refusal or you sign, it goes to the EC official who countersigns it. And I'm saying that if the EC official countersigns it, it becomes a formal complaint in the system. I'm putting that to you.
My lords, that is why I'm saying we never got to the point where we could have indicated the reasons on the form. That opportunity was denied us.
You see, you didn't get the opportunity because your very agents and representatives in the regions whom you are trying to discredit in this court endorsed the forms without complaint. I am putting that to you.
My lords, I am not trying to discredit our agents in the regions. I am saying that what happens at the regional level, which is the third level as narrated in the first respondent statement, now happens at that level. What happens at the national level, there is a reason why we were to be there. It doesn't mean that what comes from the regional level could be devoid of errors or mistakes. And it is in the process of going through that we identify material irregularities that we were bringing to the attention of the chairperson of the Electoral Commission.
Now, simply walking away or melting away, as you did, was not an option for the purposes of the forms.
My lords, if walking away was an option for us at any given point in time, we probably would have done that long ago. We had never at any point in time imagined walking away, and we never walked away. We only exercised the option of going to see the petitioner because the first respondent had asked us to do so, and we had no reason not to believe that she was acting in good faith, only for us to realize we were deceived into getting out of the place. Besides, the reason why we believe strongly that we were deceived was originally the announcement of the election results was scheduled to take place at the International Conference Center. We were all told, everybody was aware. We were all prepared for it. Less than 10 minutes after we left the place, as I was told later by others who were in the room, the chairperson, together with the officials of the EC, came to call them upstairs and hurriedly announced the results. This, for me, indicates that there was a deliberate decision to deceive us.
Melting away or walking away by you two, you and Rojo Metonuno, was in the relation of your duties to the petitioner.
My lords, we never walked away.
As a result of you being in the relation of your duty, you then concocted this story and fed it to the petitioner, leading to the filing of this ill-fated action.
My lords, if this was ever a concocted story, we would not have left our laptops and our working tools in the EC's premises in the strong room. If this was a concocted story, we would have left in our individual cars. If this was a concocted story, we had no basis telling everybody else in the strong room what the deliberations between us and the returning officer was and why we decided to do what we were doing. Besides, some of the agents, after telling them that the chairperson of the EC had asked us to go consult with the petitioner and come back, had told us that we hope you will come back in time so that we can complete the process. So there was no reason why we won't at any point in time on our own walk out of the place, my lords.
So, yes, my lords.
Because the word keeps changing. What exactly is your evidence? Are you saying that the chairperson of the first respondent instructed you, asked you, advised you to leave the room? What exactly are you saying?
My lord, I take it as...
Because in some instances you say instructed, in others you say asked. What exactly?
My lord, she instructed us to go and consult with the petitioner.
The chairperson of the first respondent instructed you?
The chairperson, yes, my lord.
Secondly, Mr. White, may I ask you to, may I ask you to be a bit slow in your answering because the recorders, yes, have to work.
My lord, unfortunately, I can't tell who is talking. I know who is talking. I can't see or whoever was talking right now. I don't have to see. Oh, okay, I see. All right, that's fine. I could only hear voices, so that's why I'm asking. I wanted to be sure it's an accepted comment.
I think it's just a camera block.
Your time, because
okay.
It's been recorded.
Okay. I'm grateful, my lord.
Now, you see, you never left any property of yours in the strong room. I am putting that to you.
My lords, we left our laptops, calculators, and bags in the strong room. I personally left my vehicle within the premises of the EC, and by the time we had returned to the place, in fact, if we did not leave any properties of ours at the place, why would we have returned to the place in the first place? Then there would have been no basis to return to the place. We went back there to get our things.
You see, you didn't leave anything in that place because that was the place that Form 13 was posted at. I am putting that to you.
My lords, Form 13 was posted at where?
The very strong room that you left. That was where Form 13 was posted at.
My lords, I need clarity. This is unclear. We left the place and came back. When we came back, the place was deserted. There was nobody else there except the gentleman who I believe takes care of the facility, who was there. No. So I'm not too sure how Form 13 comes in, because as I had indicated earlier, neither myself nor my colleague was ever shown, given, or asked to look at Form 13 and certify or sign. It never ever happened.
You see, Dr. White, you didn't see Form 13 because at the time it was being filled, you had melted away. I am putting that to you. You didn't see Form 13 because at the time it was being filled, you and your other representatives, who were the eyes of the petitioner, decided to just vamoose.
My lords, we were asked, or if you like, instructed, and I should say that I use these words interchangeably, but it's all intended to mean instructed, to go and consult with our flag bearer by the chairperson of the Electoral Commission. Now, this question about we left because Form 13, that's the reason why we did not see Form 13. At the time we were leaving the place, my lords, we hadn't gotten to where we should even be having conversation about Form 13. We were looking at results through their summary sheets coming in region by region. We needed to complete that process, and then Form 13 would have been processed based on my understanding and projected on the screen so that we can compare the values on the regional summary sheets with the values indicated on the Form 13. This process never occurred, never happened, and I don't want to believe that between when we left and came back, which was not more than 45 minutes, the entire process that involved Form 13 had taken place, everybody agreed, signed, and results were declared. I'm putting pressure on the recorders. I'm sorry, my lords. I'm sorry. I'm sorry.
But you agree with me. You agree with me that at the material time that you left, you have seen and certified 13 of the 16 Form 12s. Is that not so?
My lords, as far as I know, we did not certify 4 regions. So that brings those we certified to 12, because we have 16 regions. Now, I should indicate that even if it was just a single region that we did not certify, my lord, that for us was very important. The reason being that behind the numbers are the wishes of people expressed in votes. And we wanted to make sure that in the end, irrespective of who was winning, the declaration reflects the exact will of the people.
Now, the four Form 12s that your original agents did not sign, we also did not indicate the reasons for their refusal to sign on those forms. Is that not so?
My lords, may I refer? My lord, the 4 regions that we did not sign, the reason was not because our regional reps did not sign.
Oh, please answer my question. You make life difficult for me. Answer the question. I'm saying that the 4 regions that your regional representatives did not sign, they also did not indicate the reason for their refusal to sign on the forms as required by the CEI 127? Answer the question.
Yes, my lord.
Good. Are you aware that out of those 4 regions that your representatives in the regions did not sign or indicate their refusal, the petitioner won 3 of those regions?
My lord, that is precisely the point. If our interest was just in winning.
Mr. You see, if I advise you, when you answer the question, you can add whatever you want to add.
Yes, my lord.
Explanation.
Yes, my lord. Could you please take the question again, my lord?
I am saying that the 4 remaining regional Form 12s that your regional representatives did not sign, out of those 4, 3 of those regional forms had the petitioner as the winner.
Yes, my lord. And that is precisely why our issue should be seen as very genuine. Yes, the petitioner had won, but we were not just interested in the winning, but also the votes and whether they truly represent and reflect the wishes and desires of the people. And we have noticed irregularities that we thought needs to be rectified. If we were there only to see forms that the petitioner was winning, I believe that we would have signed. But to the extent that, yes, the petitioner won those regions, but we did not sign and had raised issues, is a clear indication that we actually were making sure that the writing is done according to law.
According to the law, raising issues must be on the Form 12s. Did you indicate any reason on any of the Form 12s?
My lords, we did not, because we never got to the point where an opportunity to indicate reasons on the form was provided. Besides, the particular form that we are talking about, which I believe is Form 12 from the regions, had no space on the form for representatives in the strong room to put their signature and comments if they have any issues. The forms that came in as summaries did not have that particular column or space provided for us. So assuming we were even stating reasons why we were not signing, my lords, there was no place available for that.
You see, if you had any reason to refuse to certify Form 12, you would have indicated on it the same way that your representatives signed, that your colleague Rojo signed and certified on all the others. I am putting that to you.
My lords, with the greatest of respect, I don't know whether it is possible to show how Form 12 looks like in this court, so that my case will be made clear. I am saying that on that form, there is no space whatsoever for writing of comments if you have any concerns. I have a sample of that form here, my lords. This is the Bono East form. The columns here have no space whatsoever.
Are you referring to a sheet from your
My lords, I'm referring to just one of the regional summary sheets.
It's coming from just your possession.
My lord, I believe so, my lord. My lord, if we go to my exhibits, the one on Eastern region, it is actually the same form.
Go. Now, can you read the right part? There is a heading. If I start from the top,
Okay.
where they sign, right? Start from the left column. Read all the headings for the hearing of the court on the Eastern regional sheet that you have.
Okay. Thank you, my lords. I'm reading it, but against the background that this. Okay. Name of agents at the regional level. Party. Name of party or candidate. Signature of the agent at the regional level. Reason if refused to sign at the regional level.
Thank you, my lord. Now, you indicated that you have not seen Form 13. I want you to look at the petition, the first respondents, Exhibit 4.
Could you please, my lords, can I please have a copy? Okay.
My lords, whatever is being shown to him, we need to know what is being shown to him. Because
my lord.
Yeah, counsel for the petitioner is saying that whatever you want to show to the witness in the box, by the would I say the practice, settled practice, the counsel must have a look at it.
My lord, I wanted to show to the witness Exhibit 4.
Oh no, it passes through counsel. It doesn't take anything away. Yes.
You know? No, Exhibit 4 attached to the first respondent's witness statement. You are looking at the Form 13 regarding the 7 December 2020 elections, Exhibit 4. Is that correct?
My lords, that is not correct.
Now, the Form 13 was signed by 8 of the agents present at the time, the form that you are looking at.
my lords, that form is not in evidence at this stage. I thought that he was showing it to him in order to raise some issues about credibility, maybe if he had signed it or something like that. But that form is not in evidence, and he cannot be asked questions about the contents of that form. It's not in evidence, my lord. And the witness has stated quite clearly that no such form was presented at the time of the event. So that form cannot be the basis on which he can be asked to make references or asking.
With respect, I wish to withdraw the
Yes,
document
it's
from
not yet in evidence.
Thank you.
Now, you see, at the time on the 9th that Form 13 was filled out and signed, you and your colleague, Rojo Metinunu, had left the commission.
My Lord, at the time this form was prepared, which by the way we don't know what time it was prepared, we have been instructed by the first respondents to go and have deliberations with the petitioner on the basis of the irregularities that we have identified and had asked and had brought to her notice.
I am putting it to you that the first respondent's chairperson never instructed you to leave the commission.
My Lord, the first respondents did instructed us to leave the place.
I am further putting it to you that you indeed did not even personally speak to her. She cannot instruct somebody whom she hasn't seen. Yes, my Lord. Yes, my Lord. Yes, my Lord. Now,
yes, my Lord.
But in your witness statement, you stated that she asked you to go. Why do you insist on using instruct now? In your witness statement, you said she asked you.
My Lord, I believe I had said earlier that I'm using instruct and ask interchangeably.
But the two words don't mean the same thing. The two words don't mean the same thing. We all know that.
Now, I am putting it to you that all the figures on Form 13 is a summary of all
back to the figures on Form 13, which is not in evidence. That's impermissible.
Mr. Chikata, he has recognized that he received training for his role. So I don't think that the question refers to a specific Form 13. Form 13 is a generic form, isn't it?
I was listening to the question that he asked.
So was I.
And I did not hear him say a generic Form 13.
Neither did he say the specific one. So let's see what the witness
In the
says.
context, the only Form 13 we've been talking about in the last 5 minutes is what he sought to tender. So in the context, I think, in order not to mislead the witness, if he's talking about a generic clear, so that the witness...
That's appreciated.
My Lord, I will address the court on it. Now, you were not present at the commission because you left when you realized that the petitioner had lost the election.
My Lord, that cannot be true because as at the time we were instructed to go and have deliberations with the petitioner in that room, we had come nowhere close to knowing who had won and who had lost because the totals as they were coming from the regions had not been put together, and of course there were issues with some of them, so we couldn't have even put the total together and decided that candidate A or B had won the election. So there is no reason why anybody should believe that we had left because we noticed that A or B was losing the election. Besides, we did not go into that room with a fixated mindset that by all means our candidate must win. We went to the room to make sure that whatever the summary sheets that were coming from the regions were reflects the true will of the people who went out to cast their votes on the 12th of December 2020.
You see, the fixation that you have is what you have just displayed in this court. Now, let us go to your exhibits that you have attached to your witness statement. Mr. Esiedun Ketia asked me to ask you about how that letter came about.
My lords, as we began noticing challenges with the summary sheets that were coming in, we considered it proper to relay the information to one, the petitioner, and two, the political party on which he stood as the presidential candidate. And as we relayed to them, we also told them that we had sought audience with the first respondent. I should say that we sought audience twice with the first respondents. In the first instance, when my colleague went, she told him that I have heard you seem to have some genuine concerns, give me a few more minutes and I'll get back to you. The second instance was when she instructed that we should go and have deliberations with the petitioner and return.
But up to that point, you didn't deem it fit to register your complaint in the mode set out under CI 127.
My lords, as I had indicated earlier,
Answer the question, please.
because there was no space on the form for us to indicate the reasons.
Oh, okay. Now, did you mean this letter to be an official letter?
My lords, the question again.
Did you mean this letter to be an official letter? The exhibit attached to your witness statement, did you mean it to be an official process?
To the best of my knowledge, yes.
Now, as a lecturer, I believe that when you deliver an official process, it ought to be receipted for. Is that correct?
That is correct, my lord.
Now, look at your document and tell us where it is indicated that it was received at the headquarters or any other branch of the first respondent. Indicate for me.
My lords, there is no indication of it on the letter, but it is important to be cognizant of the circumstances of the time between the 7th and the 9th, if not earlier. The entire Electoral Commission's building was cordoned off with heavy military and police presence. That made it almost impossible for anybody to ply even the public roads that were just beside the Electoral Commission. Now, when the letter was written, at the time the letter was being brought, we were on our way to hold consultations with the petitioner. The letter was brought in by the Deputy General Secretary of the party in...
You are saying in one breath that you were not there.
Yes, my lord. My lord, I am speaking in respect of what I know happened.
Yes. You were not there.
My lord, I believe that not being there does not necessarily mean that I will not have knowledge of things that may have occurred.
No, you can't. Unless you tell us how this knowledge was acquired.
The knowledge was acquired through interactions with those who were directly involved. And therefore, the letter was brought in by the Deputy General Secretary in the company of lawyer Sonny Lita and lawyer Marietta Opombru and other officials of the party. When they arrived, they had to stay behind the police military cordon off.
This evidence is not admissible.
Thank you, my lord.
Any of the persons that you have mentioned,
We are alive.
Yeah. Thank you, my lord. They are alive. In fact, they are present.
So let's come back to the letter. There is no indication on it that it was received. Is that right? Okay. You also did not send the letter by email.
To the best of my knowledge, no.
You see, I am putting it to you that this letter was put out by you, your party, in the public domain to create a certain scenario in the country. It was never received by the first respondent.
That is not correct, my lord.
I am further putting it to you that this letter was generated by you in order that you will hide your failings as an agent of the petitioner in the strong room.
That's not correct, my lord.
And I further put it to you that this action it came about as a result of your failings and the falsehoods that you have peddled.
That's not correct, my lord.
And I'm further putting it to you that you are not a truthful witness.
My lord, I am a very, very truthful and credible witness.
And finally, that the petitioner is not entitled to any of the release.
My lord, to the best of my knowledge, the petitioner is entitled to all of it.
My lord, that will be all for the witness.
Sir.
Yes, my lord.
Second respondent, counsel.
Now, Dr. Professor White, I'm putting it to you that you know that the chair of the EC has no power to instruct either you or Metro Nunu.
My lords, I know that.
So, I'm furthermore putting it to you that if you left the strong room, you did so on your own volition and based on your own judgment.
My lord, that's not correct.
Now, you see, part of the burden of your witness statement has been to demonstrate, as you put it in this letter, MKW1, that Ashanti region provides fundamental problems that require investigation. We have found out that almost across board, the aggregates on the summary sheets do not reflect the individual results on the pink sheets. Is that not so?
Yes, my lord.
Now, I'm putting it to you that that was the basis of your allegation in the press that over 390,000 votes had been, there are problems with them.
Yes, my lord.
Yeah. Now, you admit that in the petition of the petitioner, he makes no such averment.
My lords, I believe...
No, please. No.
My lords,
I'm saying that you know that in the petitioner's petition, he makes no such averment about 390,000 votes.
my lord, he did.
Well, the court will determine that. Now, I'm also putting it to you that when, according to your tale, you were leaving, the two of you, one of you could have remained and the other have gone. Is that not an option?
My lords, the weight of the issues we were going to discuss with the petitioner requires both of us to be present.
So are you suggesting that if one of you went and said that, Mr. Petitioner, this is what the two of us have agreed upon, so what I'm relating to you is based on our common position, the petitioner would not have heard you?
My Lord, I don't know.
That is a good question. Answer. Now, I'm therefore putting it to you that your witness statement adds absolutely nothing to the case of the petitioner.
My Lord,
Mr. Kutumba, this is a matter for addresses.
my Lord, my witness statement.
My Lord,
Okay,
so that will be all for the witness.
Oh, thank you. My Lord, can I?
Please, there will be questions from the bench.
Dr. White,
Yes, my Lord.
kindly look at an exhibit, the presidential election regional results summary sheet.
My Lord, please, I couldn't hear you.
Presidential election regional results summary sheet is attached to your witness statement.
Attached to my witness statement.
Yes, your witness statement.
Okay.
Eastern region.
Eastern region, yes, my Lord.
The one with the Mr. White, Dr. White, look at the one.
Yes, my Lord.
Now look at the far right column.
The far
Right column, the bottom part.
okay.
Reasons if refuse to sign. You say.
Yes, my Lord.
So are you seriously saying that if you had any reason to refuse to sign, you couldn't have registered with that column? I want you to be very. Are you seriously saying that this column could not take any reason for a refusal to sign?
My Lord, with the greatest of respect, this form is designed purposely for regional representatives at the coalition center at the regional level.
Yeah.
They are the ones who are required to sign, and a space made available for them and state reasons.
Yes.
At the National Coalition Center, my lords, no space whatsoever is provided on any form whatsoever to indicate why we have a concern and we needed it registered. And in fact, it is in consideration of that we decided that let's have a conversation with the returning officer and raise our concerns.
Agree. So you agree with me that at the regional level, there's a space for parties representative to assign reasons for not signing.
Yes, my lord, but not at the national level where I was a representative.
Oh, 1 minute. Professor White.
Yes, my lord.
You said you received training or before assuming your duties.
Yes, my lord.
So you've seen the Form 13 before?
Form 13?
Yes.
I have seen the Form 13 during the training process, yes.
All right. I'm going to show you a copy of the Form 13 that has been brought to this court.
Okay.
It's not in evidence yet, but I'm going to show it to you. Please show it to his lawyer and then show it to you. Do you see a column that is headed reason for refusal to sign?
Yes, my lord.
Thank you.
And my lord, if I may, this is not Form 13.
What is it?
Only the first respondent can answer. Because if you look into the CI 127, a sample of the Form 13 is there. It requires you to list the regions and list the candidates and their individual votes as obtained from the regions. This form only listed the candidates, the votes they obtained, and then subsequently had agents and the candidates and signature. So this is not contested.
So when you say that the Form 13, as you know it, does not have a place for indicating your refusal to sign, you are thinking about what is in the law?
My Lord, I have not said, my Lord, I have not said the Form 13 as I know it. I only said we were not given any form in the National Coalition Center that requires or has a space for us to sign.
Thank you.
Thank you, my Lord.
Look, Doc, I have a very simple question. Is there a reason why there should be the two of you in the strong room at the same time?
Yes, my Lord. I believe it is for us to be able to confer. For instance, the process involves a lot of calculations. And if I may, at some point, my colleague has to be mentioning the figures for me one by one, because I calculate them, both on the calculator and then in the Excel file. So there obviously was a reason why we have to be two. And I noticed that the CI actually says that agents must not be more than two.
All right. So if there was consent for you to leave, and in a heightened, circumstance like that, do the two of you go?
Madam, sorry.
No, please, because you see, you were there for a purpose.
Yes,
for
my
the
Lord.
petitioner, his eyes, body, everything was you.
Yes, my
You were
Lord.
going to confer with the petitioner.
Yes.
What were you expecting him to say? Because you were the ones receiving the original results. So if you have to go and confer with the petitioner, wasn't it enough for one of you to go so that one stay around and see exactly what is happening?
My Lord, with the
Looking at
greatest,
the atmosphere.
my Lord, with the greatest of respect, the question itself suggests that the first respondent cannot be trusted.
No.
And therefore, we should have left one person there. I indicated to this honorable court, my lords, that we acted in good faith and realized later that we were deceived. And so, yes, there was that option, but we exercised the option that will allow us to give the petitioner the best of information that was available to us. For instance, my Lord, whilst he was there meeting with the returning officer, I was in the strong room. He needed to inform the petitioner what exactly he was discussing at that time, and I needed to tell the petitioner what I was observing whilst I remained in the strong room. So it was important that both of us left.
Doctor, I want to be very clear on some of these issues. Now, you already told this court that you were not sent to the strong room to take instructions from the chairperson of the first respondent. Is that correct? Your presence in the strong room was to see to the cause of the petitioner, but not to take instructions from the first respondent. You were asked this question and you admit and you said yes.
And I indicated that.
You said yes, you were not to take instructions from the first respondent.
My Lord, yes.
So, when the first respondent said, go and consult the petitioner, what were you going to discuss with the petitioner? You were in the strong room for a purpose. He told you to go and consult the petitioner. On what? I want to know.
My Lord, on the specific irregularities that we have brought to her attention, and she did indicate also that the reason she was asking us to do so that all the stakeholders, including the NPP, Peace Council and others, could be invited to ensure that we have a credible result before the announcement is made.
But you know that part of your duties in the strong room, at the end of the day, if you have refused to sign, was to indicate the reasons why you had refused to sign.
My Lord, it appears to me that there is a particular side of this narrative that has not been very clear. I am saying with the greatest of respect that the forms that arrived in the room and within that room itself,
I don't mean
there has been no space whatsoever for us.
No, I don't mean that. I am saying that at a point in time in the strong room, there will be a time for you to indicate your displeasure on what has happened.
My Lord,
to the EC.
we know that, and we had hoped to get that opportunity, but that opportunity was denied us.
Please. Then, you see, would it be right for me to say that by taking contrary instructions from the chairperson of the first respondent, granted what you are saying is true, you did not help the cause of the petitioner who sent you there?
My Lord, I don't believe that is true. We were working in furtherance of making sure that the results that ultimately gets announced by the first respondent reflect and represents the will of the people. And if she asking us to consult with the petitioner is part of how we could get there, we were happy to do it.
But then, seriously speaking, you did not take your training seriously. No, please.
It's not an appropriate question.
I want to be clear. You've gone to do a particular job. Then instead of doing a particular job that sent you there, you take instructions from somebody else. Then you leave your job. Is it that what I want to find out? Then you did not help the petitioner.
My Lord, with respect, his lordship is entitled to his opinion about what the petitioner did. In terms of factual evidence about what he did and the reasons that he has answered. He has, in terms of, his lordship can have his opinion. That's his opinion to have, and he can have it as well. But in terms of what the petitioner did and why he did it, he has answered the question. So I don't think he can be harassed with these opinions.
Please, I take difference to that. I am not harassing the witness. It's not my duty to harass him. Well, I know that he has been sent by the petitioner to do a job for him. Then somebody tells you, oh, go to the petitioner and consult him. If the petitioner could do the work, he himself would have been there. That's what I want to find out. But how am I harassing him?
Well, you're harassing him respectfully because the petitioner has indicated that it wasn't just somebody told them that go and talk to the petitioner. The petitioner has indicated that the returning officer...
The witness or the petitioner?
The witness. Thank you for the correction. The witness has indicated that the chairperson, not just anybody, the chairperson, who is the returning officer, was the person with whom his colleague had the conversation. And on the basis of that, they were sent to talk with the petitioner. And he has given every account of why they thought it fit that both of them should go. Now, so if repeatedly an opinion is being put to him, that is harassment of the witness, and that's not allowed.
My last question.
Thank you.
My last question, Doc. Just by the way, what do you lecture at the University of Ghana? The subject, please.
My Lord, I teach public policy.
Okay, thank you.
All right, I have one more question for you. I want to be clear in my mind. You said in evidence that you never spoke to the chairperson or the first respondent. You said it.
My Lord, I did say I never spoke to her in person.
Yes.
But I do know that my colleague had spoken to her on our behalf.
No. So how did she instruct you? The person never spoke to you. You have admitted on oath.
My Lord, I am surprised at this question. The reason being that...
Why are you surprised?
I'm surprised because...
the question I'm asking emanates from your evidence.
Yes, my Lord.
So wait.
Thank you, my Lord. Sorry about that, my Lord.
I'm saying that you have admitted on oath that you never spoke to the chairperson.
Yes, my Lord.
So I'm asking, how was the instruction issued? Is it not a fair question? Why are you
It is a fair question, my Lord.
So why
the instruction was issued through my colleague, Rojo
Yes.
Meteldono.
Yeah. So
And on the basis of that, we had to comply. Thank you, my lord.
No re-examination.
This is Angel 102.9. This is Angel 102.9. This is Angel 102.9. This is Angel 102.9. This is Ghana's own Angel 102.9. 102.9. This is Angel 102.9. This is Angel 102.9. This is Angel 102.9.
Order in court, please.
This is Angel 102.9.
The council, may we know whether this is the last witness for the petitioner?
My lord, we have an application in respect of our request for inspection of certain documents. And the outcome of that application will determine whether we ask leave for a further witness, because we've only filed two witness statements, and we will need to ask leave. But the outcome of the application that we have pending will affect the decision that we make.
Thank you. Yes, Mr. Amenugo, have you been served?
Yes, my lord, you have been served.
Okay. Yes, Mr. Kotamba,
My lord,
have you been served?
been served.
Then, do you have any objection to the application?
My lord, with respect, can the witness be...
Oh, let me discharge him. Yes.
Can he be discharged?
Yeah, oh, certainly.
Thank you, my lords. I'm in a hurry to go. Thank you, my lord. Order in court, please.
This is Angel 102.9. This is Angel 102.9. This is Angel 102.9. This is
My lords, with the greatest respect, I mean, I appreciate, yes, but my lords, is it that the Supreme Court requires people to be in a suit? Yeah, but
Well, we insist, it is just an advice to him. It's nothing. I'm not taking anything away from him, sir.
my lords, the only reason I rise in connection with this is that if the word goes out that whenever lecturers are coming to the Supreme Court, they have to be in suits. Because I mean, that...
Order in court, please.
we are raising the status of lecturers.
This is Angel 102.9. This is Angel 102.9.
Sorry, Mr. Menuvo, are you opposing the application?
Yes, my lord. So I have...
Mr.
My lords,
Akotamba,
we are opposed to...
okay. Then we will adjourn it to tomorrow. Yeah. If you have any process to file, Mr. Chika,
No, my lords,
yeah. Please, we want to, sorry, excuse me. Please, Please, do you want to have it argued today or you?
Yes, Lord, it was filed today and served today. Lord, if you, with the kind permission of the court, get an hour and a half, we can come and file our position if my lawyers want to take us later in the day.
My Lord, then we might as well be given the opportunity to file it by the end of the day and we'll argue tomorrow.
This is Angel 102.9. This is Angel 102.9. This is Ghana's own Angel 102.9. 102.9. This is Angel 102.9. This is Angel 102.9. This is Ghana's own Angel 102.9. 102.9. This is Ghana's own Angel 102.9. 102.9. This is Angel 102.9.
Order in court, please.
This is Angel 102.9. This is Ghana's own Angel 102.9. 102.9. This is Ghana's own Angel 102.9.
By court, the petition is adjourned to Wednesday, the 3rd of February 2021 at 9:30 a.m. for motion for an order for production for inspection of documents.
All right.
If after the motion there is the opportunity for us to continue, we may do so. Thank you.
All rise.
And then 10 times in the court in Apeja, and we're channel on Besaba. Now, it's not one by one Bebanina. Ebijna Bushibi and application, Chatua filing, and East lawyer says, Zakakwatu, Phantom, oh, Papa, Umbitma file or more there. But the iron is so nice to say, Akutampa, Omonso, Ayo there, the lawyers for the second respondent. Into the Akusina and say, court no Apejani. Say, Namaya, the Machina, pardon, Kono. So, Muti, sa application, we not a quite a wa. And you're not one. Ever to us, but your me and Kasame was 17 questions for lawyer Antifu.
Is it under cross-examination?
Yes, summarize the course of correct.
Summarize, we and I mean, some questions.
Reporter, that's a reporter in Yankwama, to summarize it.
But would they say or can they see
a TV should hear more summary to it? You know, say, and a Supreme Court to Tenasson, no Nipa, witness number 2. You're a Pesa White, witness number 1, see a Dunkati, and to didn't go to Dakam Sanye. One that was strong more, but Kaya brand, see a Dunkatia, General. Can send him no, or say strong woman commodia, Chese, you're a Pesa White, or witness number 2. And a bet me about Kadi, see or hopper tinty, or buy no woman fra Sebisano, he's lawyer betre eye respondent number 1 yera manuvo ne frase ebisa ne nsemfa abatwo ehyehyeye da ho kwan e fa so a entity a onya ye strong group adwuma no waye ne sen no so the first time ni ya wo ye bi yera pesa wa ne kan ene ade ne niema hodo e course ye onya ntete no fa strong room na obisa no about some of the mmea hodo anase a friend say vote or more kind way your work constituencies ahodo no bia na regions ni bibisa no say na Ashanti region ti so mo certify so wo mo ye no bisa no say na Ashanti regional you know ho no so nyanya bia no result ni ba say ne yera brojaja if you no so de ne sase also wo mo bisa po answer say bia result bia ba na region no mo ho ne say also butumi sign no ma sign ba mo say ni we tie no mo say no how kakra ho na ade ba kwa na interest na nkofo party ene yesmaye no ebra edu baby yesmaye na hono na quite interesting but who say yera pesa wa to be sad nsema no akire mu a we de nene nka anye tenten na hono ne ye bi sasa nyanya bia soma na wo say yesmaye no enye no kore say yesmaye ene wo so yesmaye no wo say nti ma me je na soma wo wo so wo nyam na wo so ame
the first no a lawyer for ni busa say strong room hono wo kwese say ko take instructions if you be one na
yo no correct
and no say
there be enye sa
e ho de yenje instruction if you be a ho when you featuring na so wo gine na wo kan
wo ade we are na report be na ade ama wo candidate any party
is lawyer ni sa busa na say ayenye bia na maame na ye friend Jane Mensa no wo ko strong room ho no woni ni hyiai woni ne kasai o se da maame no me
won suma no
ma ne na nkasa da mante na no asem kura
bo sa kasa na centrofo ni ho
o se na centrofo bi ni wona ono mo na friend
prenu so mo mra na
sa centrofo no mba he o fra no mba gina he
ene o ma mi sa
nti so wan kire
wo ma mi sa
okay na eyire so anti o wie yi
ene o kire se suma na suma de ba ye no wenyo onu no ye onu kra de wote rojo metri nunu enu onu de kra de ba se asoma o muntu o mese nko wonu so nya witness won ko ma ye di mu yet
ya wo de to ba sasa na makofi ando ba wi
ana kofi ntrem
na kofi wi a se de justice apabusa no
isi se pesa wa to metna yin so bi mo onya witness o mo na wi
o mo discharge
o mo na wi
wo se eni kwansa wo je instruction bi afi obi a ho ma me no wo se wo de na nkasa na afi wo se ma me no na soma mo no so da bi me mo de rojo na ka kire me se ma me no se sir kofi adoma
I think rojo explanation be o ha nke be
I said rojo the explanation be ba kofi wo te me nka
after me to nka pa
na e hot sense say
the meeting I can say said you who screens no so no atem a lawyer for ene wo mo a ejina mu de ema John Dramani Mahama ene who say wo mo api eba begina anim ho no aso say ne wo mo ne be di kan address media no ade a ye hwe said e ebeko but quickly no o sha questions are free atemuafo no ho eba ye etwa ato no seem massive say no etwa asem ni nyina summary wo hwe ene de course as afi no obi adjoin a ni nyina ne say nipa no ye dance ni anase osi John Dramani Mahama anemu wo ye dan a ye fe ne say strong room electoral commission ho no na say oba na obeyi nsem ahodo bia no nti Dr. Pesa White ene oba begina mu ma oboni din nyina Michael Kanidin no ho mo kire na adwuma a wo ye say wo lecturer wo university ma o hwa akire no na tade a wo hye ba ye ho asem pie kakra ma chachu sorry say minim say sa temuafo no pese mo kire say so be a lecturer so hye si tuba court a mo de sere kakra but on the whole no the koba ene say no wo mo hawo bia na enkrata e wo strong room ho no emma kwan mo ntumi ntwere wo mo hawo no ana enti wuti asem misa a free bench by the na edikan no a na or peja a year and crata bia a year summary sheets and I said a funny pink sheet be a free eastern region and watch us on corner or space be and ye biana or more how be a woman to me entro or wana and no and na or says I will share form no ankasa and said ye tianoa ye make provision bia for an senior or war a year strong room hot so to me actually no asem and wachi and ye bisa no say onya training ankasa Emma oche mu say I onya training na o share DNT and
This is Angel 102.9.
Kofi line no breaky every Supreme Court na bigidi say enche a lawyer for no be address media no na de woman no
and this a lawyer for ne pie kane mama Marietta Brew hu no pesa white gina hobby a o mo kire say entire chem next time ya o ba court a o mo she suit
and come 17 questions to lawyer antifo no
you bisa yera chatika bisa say no professor for na fi school ba no mo tira de no mo ba no mo she suit ana na me say judge ba ko say this is the Supreme Court na me say no formal you can formal I just suit be a lawyer na better
I will say Supreme Court judges no senior omo court na nkasa tie ene ade no say o kan sembi na say yagitu mo no ma one way or the other be mra ayesusu bia ha enti
and me lawyer pacho court me first question out of 17 first one they say you were dressed na the court ana
yo me da sepi for lawyer for the your dress na yezo court.
Okay.
In fact, color crowd bit all that shall cry. Nya color bia suit to cry. Nya color bia no botumi za court.
Hey.
No. Inti
pink suit.
Usual lawyer black and white.
Hey.
Inti se nenu dum kakra oya color black and white maybe blue, dark black colors bina dena on the bottom we bonye gudu. But yeshen wa say in there on the or oil white.
Okay.
Sometimes you court district court na zini bia because yeshen blue and the different a little bit color be on than your white can be but Supreme Court
because my consecutive court I mean who lawyer be
some a lawyer now we shirt no was on your white one two or come with you home. Supreme Court today into me for color be apart from black and white.
This is Angel.
And I was going to miss so all black and white, all colorate outdoor kumi or white BBR. Now a public in this you need particular dressing for public. At to me water or color be up there. Nemum BBR beer, me do to me see there. Atara another dressing the beer. Generally yen na obi ahun bo hu de is on ye papa so ezokwa wo botumu akacho de maybe or indecent dressing botumu apomo fro but you need particular dressing into ehwema time na ade akasakasa ba ho kakra wo Dr. Kwesa White ne na term no enhu de Chief Justice Kede onyaza or insist there but no right or route in the for keke next time why be but on kada or yambra or shen brother or there chinchina or then cautious suit and other politician what I wish a political suit to said but maybe in maybe an argument or you don't be to them but on yet right there local quarter and so but my show water but my show natural show
time metum is white ya
yo atabia o kala bia senior lawyer nkotin za
momentum de jeans ako
but me jeans
na t-shirt
oh bibia
na say a lawyer na oh sorry
no I wanted to answer basically dressing beer onye accepted in the general public situation they will not accept
it
but after the color combination it doesn't really matter
and court bia into me shechel one rig gum there to them na gum showing na kwesewano into mkatina ho mbo papers in there can papers na no need am na mani na anti ya pede
another little
picture no pedo bia no concentration ko azina yendo into what dressing just has to be a bit decent now there no particular dressing for the public and the colors to them for
okay
with my yellow on phobia so long as I'm your lawyer
and to say a lawyer na Ebia, what are no shots no? I didn't some motion black and white and was
tell you maybe I want a bring us a language and the way I see as the and I think you're dressing and can on people and cat. These days, you're entirely share wig in a gown of papa. They be a mission miss suits in a mash me white shirts in a my bomber collar and a good name Zuko and last Chief Justice. Okay, young son, young wig and gown.
Okay, now, young Supreme Court in a young far
irregularities that were significant in terms of the integrity of the results. They left in good faith, in the expectation that after consultation they were going to come and continue with the process as stipulated by law. Witness, that was not to be. Immediately they left. A few minutes after they left the strong room, witness, the chairperson of the Electoral Commission, to be. So immediately they left. A few minutes after they left the strong, went ahead to declare the results in their absence. Now, she basically ran all the time-honored practices and conventions that were established by her predecessors. There is a precedent that was established in 2012, where the New Patriotic Party agents raised a number of issues relating to the results that were coming in. The former chairperson of the commission, in the person of Dr. Afarijan, called a meeting of all the parties and their agents and the key stakeholders. And they sat around the table, addressed those concerns that were put before him, and then ultimately declared the results. And we were all witnesses to what happened thereafter. The current president brought a petition together with his vice president and the late Jake Obiche-Bilamte to the Supreme Court, and it played out for 8 months before the Ghanaian public. So what happened on that day when she decided that she was not going to wait for them, out of respect and courtesy and in accordance with due process of law, to consult with His Excellency John Dramani Mahama before coming back for them to redress the issues, that the concerns that had been raised, shows the utmost bad faith that she exhibited. It also shows that she was determined, and this bears repeating, she was determined that by hook or by crook, His Excellency Nana Addo Dankwa Akufo-Addo would be declared the president-elect of the Republic of Ghana. Now, I am sure as you watch, there was a lot of, how would I say, questions relating to the so-called Form 13. Now, that is the presidential elections, declaration of presidential results form. You notice, for instance, that counsel for the first respondent on his feet tried to smuggle in the Form 13, the so-called Form 13, through the back door, because that wasn't an exhibit attached to the witness statement of Dr. Kwesa White. When lead counsel for the petitioner, Mr. Tachuchi Kata, objected, and his objection was upheld, one of the justices of the Supreme Court, to our utter surprise, decided that that must be made an issue with respect to the evidence of Mr. Kwesa White, Dr. Kwesa White, sorry. And through her, the form was shown to Dr. Kwesa White. Now, ladies and gentlemen of the media, Form 13 is not a figment of anybody's imagination. It is a creature of statute. It is in CI 127. Now, Dr. Kwesa White made it abundantly clear, and I am sure this will come out during cross-examination, that what was shown to him was not Form 13. And counsel for the first respondent was in court. He did not object to the fact that Dr. Kwesa White described it vividly as a form other than Form 13. Now, what does that tell you about the credibility and integrity of the elections results that were declared by the chairperson of the Electoral Commission? If you can declare elections on a fictitious form, and I say fictitious advisedly because that form does not conform to CI 127. So where did she get that form from? We will leave that for you in your questioning of the EC, in your questioning of the second respondent, to elicit the information with respect to where that form was gotten from. Then also the venue of the declaration. It came out very clearly that the venue of the declaration was changed without consultation. They sent invitation letters earlier to all the parties. And we were all aware that the declaration of the presidential results for December 2020 was going to take place at the International Conference Center. But because of the lack of good faith and the fact that she was operating from a predetermined position of declaring the results in favor of Nana Addo Dankwa Akufo-Addo, immediately the agents of the petitioner left. She hurriedly went upstairs and declared the results in their absence. And now they are in court blaming our agents for leaving, even though it was at her instance that they left. And by the way, you don't need to communicate to two people before your message will sink. She communicated with Honorable Rojo Metil-Nunu regarding the consultation with the former president, now the petitioner. And so it was not absolutely necessary for Dr. Kwesa White to have had a conversation with her before proceeding to go with Rojo Metil-Nunu to see the former president. So if you saw the line of cross-examination by lawyer for the first respondent, and then subsequently and unfortunately by some of the justices of the Supreme Court, indicating that Dr. Kwesa White ought to have been present when the conversation took place. That was rather unfortunate. And you saw some of the scenes that played out in court today, where the witness was being harassed left, right, center, because his evidence clearly was against the grain of the narrative that the EC and Nana Addo Dankwa Akufo-Addo's lawyers have been trying to put out. That both of them left because they did not want to, they noticed that their candidate was losing. So we are here today in very high spirits. I can see from the, the faces and the body language of Professor Nana Jane Opoka-Jiman and my chairman that we had a wonderful day in court. And I am sure that, in fairness, if this evidence is anything to go by, on Judgment Day, we will be smiling. Any questions?
And you know, and it's a lawyer for led by Openi former Attorney General, former Deputy Attorney General, Dominica Ayeni, on our address here. Obi Busa question. Now, said microphones are very far from.
Why didn't you allow one of your representatives to remain at the strong room whilst the other?
The witness himself explained why that is the case, and that was because the two of them played different roles as agents of the petitioner. And it was important that they both, would go and explain the concerns that had been, observed. So, for instance, if Rojo Metilnunu forgot something in explaining to the petitioner, then Dr. Kwesa White could fill in the gaps. And then also, we gave her the benefit of the doubt. We left in good faith because she was performing a constitutional duty. And we thought that she would go by the letter and spirit of the Constitution, and that she would also go by the letter and spirit of CI 127, which require that you don't finalize, okay, and sign off the results of a presidential election without the agents of the political party. These are time-honored principles and conventions that have been established within the EC and within IPAC for purposes of the declaration of results and for the sustenance of the credibility of results. That didn't happen. Yes, sir. Yes, sir.
Yes, sir. Thank you very much, Counsel. Having listened to the testimony of Dr. Kwesa White, most of his testimony bothered on information given to him by Mr. Rojo Metilnunu. I don't think that
matters. The fact is that there were two agents of the petitioner working in concert to advance the interests of the petitioner. And so relying on one agent's information or advice with respect to what to do, for me, that doesn't matter. It doesn't take away from the fact that the chairperson of the Electoral Commission acted in bad faith. Any more questions? Person of the Electoral Commission acted in bad faith. Any more questions?
Yes, Doc. A number of very short questions. Number one, listening to you, I get the impression that some of the judges misunderstood the case that was being presented by your witness. Indeed, the witness himself had to, on several occasions, try to address and readdress some of the concerns. Now, these are the people going to pass judgment on the case that you have brought before them. If they have misunderstood you, and on the other hand, you are saying on Judgment Day you will be smiling. Will you indeed be smiling? Number two, indulge me, please. Number two, there's a question of harassment of the witness. Indeed, a lot of us watching who are not lawyers and who have always held the court in high esteem, and the judges for that matter, were scared at a point when we saw the witness in a kind of a direct confrontation with some members of the bench. And indeed, the lead counsel did same on the question of harassment, which matter you have repeated here. Is it safe for you and your case with that kind of a direct...
Can we take your questions one at a time? I'm even beginning to forget your first question, right? So let's take your one at a time. Can you summarize, crisply the first question, and I'll take that and we proceed to the second one. Whether or not they understand, take that and we proceed to the second one.
Okay. So the first question has to do with some members of the bench misunderstanding your case.
Okay.
Are you worried about that?
I don't think so. I am pretty sure there was nothing unclear about the evidence that he gave. All right. Judges are allowed to ask questions for clarification. What they are not allowed to do in terms of the law and ethics of judging is to descend into the arena of conflict. Now, as to whether they descended into the arena of conflict, I will leave that to you to judge.
Number two, on the question of conflict and harassment, what we saw in court for a lot of us who don't understand the court processes, is it healthy for you and your case?
That has been given. Okay, he did a good job of standing up. Okay, as far as the issues that he was called upon to address are concerned. He was very credible. He was eloquent. And you heard the judges saying that he should stop lecturing.
This is Angel 102.9. This is Angel 102.9.
The former president, whose case it is, had attended to the court.
The former president is well, and carrying on, the business of being the leader of the NDC. Of course, the party chairman ably represents him on a daily basis. In fact, chairman has never been absent, and I am sure, and of course, the running mate is here as a person who was on the ticket with him, and she has not also absented herself even once from court. So there's no issue about representation. The former president is not required to be in court on a daily basis in order for his case to be heard. Otherwise, if that were the case, I'm sure the judges would have been asking where he is. Since they haven't asked, it's in order. Would have been asking where he is. Since they haven't asked, it's in order.
Doc, you've put in a request to inspect some documents. Earlier, I had seen a process that was directed at the Electoral Commission. Right. If you could explain how this is different from that one. And second, of the documents, are those not documents
that is so. You will recall that we filed a notice to inspect the documents. The notice was duly served on the respondents, and the first respondent in particular has custody of all those documents. And by the way, this is to inspect the originals. It's not about us not having the documents. We want to authenticate what was provided to us and what has been put on the website of the Electoral Commission. And that motion will be heard, tomorrow. So I wouldn't want to take up some time on that one. Commission. And that motion.
Doc, thank you. I'd like to help to break down one of the issues to the understanding of our viewers. It's got to do with the witness using the words asked and instructed. To ask is not the same as to instruct somebody. He used the words interchangeably. He doesn't work for the EC and therefore should not have been seen to be taking instructions from the EC. And if the EC actually asked him to do something, he wasn't compelled to do that. You've spoken about acting in good faith. Yet, as my brother asked earlier, you had expressed...
Thank you very much. On the question of the difference between asking and instructing, I think Dr. Kwesa White used instruct in order to emphasize on the fact that they accorded some level of respect because she is the authority, the ultimate authority. She is a returning officer under the Constitution. And all the political party agents in that strong room worked, if you like, on her instructions, on whatever directive she gave, to the agents. And so the fact that he used the word instruct does not in any way, suggest, that they were taking instructions from her instead of taking instructions from His Excellency John Dramani Mahama. Remember that the petitioner was their principal, and as agent they worked, directly to the principal and for the benefit of the interest of the principal. And so I don't think that it makes any difference whether they took instructions from her or they were asked to go and consult with the former president and they duly complied. As I said earlier, they were acting in good faith. Little did they know that the person they were dealing with was acting in bad faith or intended to act in bad faith. Yes, and they came back after 45 minutes. Okay, and the question is, why could she not wait? Okay, we waited, this was on the 9th, right? We waited 2 days for the results. We could have waited another hour for the results to be credibly, compiled and released to the people of this country. for the results to be credited,
yes.
To the people of this country. Well, yes, but the thing is this, my brother, okay? Yes, she is the only constitutional officer that you have to work with. She is the sole constitutional officer that you have to work with. So the fact that we express, some reservations about her even-handedness and so on prior to the elections, doesn't mean that we could have stayed away from working with her. And we decided that we were going to work with her in good faith. She decided otherwise.
All right.
Thank you very much.
Let me do that quickly. Wait. Sorry.
Right, Baba Jamal, the country.
And Debia Samoa can say electoral commission. As our bonny team posse, a Quambias no Obama, a Yanana Kufuado, I president, no, and ne Uche or Bimfo Pesa White. Then some more the beto a year court enimno, a day the pefe say a do baby crano, or dada ye nipe name Sifu no more them ho. Say Omunko no omune. Eye John Dramani Mahama candidate no eno nkodin kita ho esan nsem bia na o ma pagya enko ye wodem ho ewie kire no o mu si abonten a o mu koye no enu sima mienu anamiensa kra no okoye eno oko declare elections no na edikan o se hunu se na wanya dikan ka kire Ghana for ina se election ye be declare no ewo conference center ensu o ka kire o mu se woman calling and coding guitar no mum from where I am rano. Woman see a bontia a new 45 minutes and electoral commission them woman could declare at the end. And then so I say form will be or use to declare results no form no ha. And then judges move back a bizarre form and for electoral commission because not at the end any evidence no pagya say onhwe form yi na se form we no baby o wa yesa na form a ode baaye no sa form no enye form a ewo mre enie CI 127 a kire form ko a yemfa declare results no inti say when you use that form and declare results na results no papa ana enye papa ni etwa to okura atetia and white or tea adakanum na yeson abasa yeson na TV yeson na chi adentie sense as some kano or kire kwantre ni esi wodem ho emma ye lead council owura chachujika the press story ka say we atetia na obroni friend harassment no emfata say ebesi Supreme Court ma mu ina mu hui but enna ni esi no ye NDC for the M say ye ni age akoni ye senia na ye pe no kure no akyase edi ni enim say ye kwa enim no kure na nkasa ebededi ya sa file application bi ye pese ye kokotwe electoral commission documents odi man na original na odi man no ye pese ye kokohwe ochina na Supreme Court behwe no ohwe no nso a ye beto otefo ye demo ase.
Thank you.
Intino lawyer Baba Jamal and I would say in Kano Yeshua Kwan say MPP for and so say MPP I said we a legal team for the petitioner the train the legal team from the second respondent now on Swaba who say information minister Kujo Ponkruma
the lawyer from information minister and
colleagues, good afternoon. We want to share with you a few thoughts as the court rises to resume sitting tomorrow morning. First of all, we on the side of the second respondent view today's proceedings as a very excellent day in court. And it's an excellent day for us in court because the issues are beginning to unfold one after the other before the eyes of all Ghanaians. Remember, this is a petitioner who came to court praying or invoking the powers of the Supreme Court that the results of the 2020 presidential election, when properly collated, come to a point where nobody got 50%. And therefore, they are asking for a rerun. And you would expect that they put witnesses in the box to advance this argument or to provide evidence that buttresses this. Today, as you've seen before your very eyes, their witnesses are here making claims of bad faith, which claims are questionable, now raising questions of the venue of the declaration, now suggesting that in one breath they say they never saw the Form 13, in another breath what is being tendered before the court they say is not a Form 13. Now today 3 key matters have been settled in our opinion. The first is this fallacy that was being initially expressed and amplified through Dr. Michael Pesa-White, that the chairperson of the Electoral Commission instructed the representatives of the petitioner to leave the strong room. And on their blind side, some numbers were put together and announced. We are beginning to see clearly that that fallacy, at best, is something that cannot stand cross-examination. You would notice that it's not just an interchange of words, instruction and asked. And I want you to take particular notice. When you read when you read the witness statement, the witness statement says, we were asked. Check the definition of asked. Now, in the witness box and under oath, he seeks to amend that and escalate the claim by saying they were instructed. And that's why you find the Venerable Akoto Ampaw did not take too much time in his cross-examination. He asked one key question. He says, I put it to you that you know that you cannot be instructed by the chair of the first respondent. And you heard under oath, they could no longer tell that on truth. He said, yes, we cannot be instructed by the chair of the first respondent. And we are clear in our mind that that fallacy has been settled. And the court will take notice of it. That it cannot be true that the chair of the Electoral Commission would instruct and that the representatives of a candidate will obey that instruction. Indeed, questions as put by the council that you selected an option, you elected, and that you were derelict in your duty. That is what happened. And we are very happy that that is being settled. Another matter that is being settled is the attempt of the petitioner and his witnesses to surreptitiously question the results by discrediting their own agents. You notice that initially from the beginning of the case, they sought to make an argument that numbers had been cooked up and that the EC's computations were incorrect. Yesterday you saw the very skillful general with a calculator now arriving at 4751, 4751, 4751. Today they tried another tactic by trying to suggest that there was something wrong with the results that their agents had certified from the polling stations through the constituencies to the regions. And in cross-examination, you saw it clearly come out, and it being settled that they could not use the back door to discredit their very own agents who certified the results from the bottom up and then claim that somebody from National had said that the figures did not add up. Another matter that we believe the court will take notice of is the attempt by counsel, and we believe successfully, to settle the dereliction of duty of the persons who were nominated by the petitioner to go into the strong room and assist in the collation of results. Now, please check. The NDC and candidate Mahama accredited 4 people. 4. In the end, 2. And this is after they had done their parallel collation in their collation center with the TV screens, one of which you saw Mr. Mahama pointing that they were winning or that they had won, and then their press conferences. After certifying or accrediting 4, 2 went into the strong room and left after all 16 regional returns had come in and 13 of them had been certified by Rojo Metilnunu, who was the leader of the two. And notice something interesting. Dr. Kpesa-White says that Rojo certified one of them in error. I'm sure as we go further, that will be dealt with also in addresses. That these representatives of the candidate ended up sitting there and even certifying some in error. It's a different matter that will be dealt with. But what is also instructive to note is that, and I think one of you asked a question, you are not judges. Many of you are not lawyers. But you even spotted it. Now, how can you claim to us from the beginning that this EC commissioner, we don't trust her? There are so many problems with her. In your press statement, you say she's doing the bidding of the MPP. Then you claim that she instructed you to go and consult your principal. And out of the 4 accredited people, the 2 who were there both left. Why? And it was interesting listening to them. They said that they wanted to go and fill in the gaps. I'm sure you heard them, that they were going to fill in the gaps. One of the key things that is becoming interesting is why Rojo Metilnunu himself did not mount the witness box, take the oath, and say that he was instructed. We believe if he had done that, he would have been caught for perjury, because he cannot take an oath and tell an untruth. And that is why they have resorted to Dr. Kpesa-White, who now admits that he never spoke to or was never spoken to by the EC chair, yet he was a subject of an instruction and he was instructed. But the one who heard the instruction, the one who went to the office, is alive, is available, but refuses to take the witness box. We think that it is becoming very clear that as these matters are settled, and as we connect it to the principal issue of did anybody get more than 50%, was the declaration in breach of Article 63.3, the key questions will now come out and be answered. Now, another matter that we need to draw your attention to is this Form 13. There was this claim to suggest that the document that was shown to the witness was done through the back door and was not Form 13. First of all, let me make this point. Every practicing lawyer knows that after cross-examination, the bench has room to ask questions for clarification. And you hear the learned justices always say that we want to understand this one clearly. So to create an impression that when they ask you questions, they are harassing you, is part of the NDC strategy to begin to poison the minds of the general public against the bench. Because they can begin to see from the questions and the answers that the balanced panel. They have already been arguing that they have not been treated fairly and that some of the decisions don't make sense. Mareta Briopong. And today, they are furthering that by trying to poison the public by saying that they are being harassed. The bench has the right to ask questions. We believe that when our witnesses get into the box, they may even be asked questions. Nothing wrong with that. Now, this Form 13, which Mr. Kpesa-White under oath claimed did not have room to state reasons for non-signing, is on page 62 of CI 127. I want to encourage you, my colleagues in the media, pick a copy of CI 127 and look at it. The last column on your right says, reason if refused to sign. That same column is available on the regional summary sheets at the constituency level. Why? Because it amounts to a certification of a complaint that will go up to the higher level. So if all your 275 constituency persons did not certify any complaint, and on your regional forms, you have gone ahead to certify all except Sehiwi also, which later Rojo Metilnunu now certified in the strong room, and you claim he did it in error. You don't come with a bad case now to come and say that there was no space on the form to fill in a complaint. I'm sure you all heard it. The blatant untruths being told before the court. So we are very, very clear in our mind that the matters that the court has settled for itself, which is to determine whether or not nobody got 50%, whether or not the declaration was in breach of Article 63.3, as compared to the matters that they are seeking to attest to today, show clearly that what they've been saying, when put in the box and put under oath, is difficult to defend. We'll take your questions if you have any at this point. Yes. Go ahead, sir. Yes. Go ahead, sir.
The import of any cross-examination is to discredit the petitioner. You've explained why your cross-examination by your lead counsel was short-lived, but do you think that he succeeded in discrediting the witness of the petitioner?
Well, as I've mentioned, or not. But as you all watched and followed on television, you saw a witness under oath say that there's no room to state reasons and be confronted with versions of it that show that there's room to state reasons. You also saw a witness who in his witness statement had earlier said that I was asked and I changed it to mean instructed. And then when put under further cross-examination that, but you know you cannot be instructed, admits that, well, actually I cannot be instructed. You saw a witness who claimed he had been trained, yet claims that somebody instructed him to act contrary to the training that he had been given. So it is not for us to determine whether or not it succeeded. You saw it, and we are hopeful that the bench will come to a conclusion on that at the end of the day. If you look at the case they brought and the witness they brought, was this witness here to prove that nobody got 50%? I'm not sure you heard that witness prove that. Was this witness here to prove that Article 63.3 had been breached? I'm not sure you heard that. This witness came at best to say that he was instructed together with Rojo to leave, and later when put to further cross-examination admitted that he cannot be instructed so to do. That was the main thing that this witness came to do. As to how that answers the question of 50% plus 1, I'm sure the bench will decide. %+ 1.
The when and where of the declaration on the 9th of December. On your side, at what point did you know that the declaration was going to happen at the
issue with the venue of the declaration of the presidential election results and suggest even faintly that therefore amounts to an illegality or an unconstitutionality? They never raised it even in their pleadings. So when you put a witness in the box and you have made pleadings, the gravamen of your case is that nobody won 50%. You have made pleadings, the gravamen of your case is that the declaration is unconstitutional. And you bring a witness and the crux of his argument is that I was instructed to leave. And they did the declaration in a different place than they had earlier announced. If it's our imagination, we look forward to what the court will say on that. What I find interesting is a comment made by Dr. Aina here, that the exchanges between them and the bench today has no probative or has no effect on the probative value of the evidence they have put before the court. I find it very interesting. And I agree with him. We are hopeful that in a possible, because this case can only end two ways, either we win or they win. In an event that they do not win, they do not come back to cite such matters, that this is why, because they have told you that they know from their 25 years of practice that it has no effect on the probative value of the evidence before the court. And we all look forward to that. My colleague Nanabi will do a quick piece summary for us.
Abushanfo we there, Madama, ye bebo no tew. Yedi kan ene ayeda etoso enso a ye ba court ene Dr. Kesa White ehye adakam ne toto na no yenya ye hu kwan a ne nsem a na oka no ensisi so. Obusa no asamo a na ose ne colleague Rojo Metonunu inso yamfa no ama metena adaka mu. Ne etoso mienu ade ba ko ese pie ne se opani eye Kesa White eko grantee interview oni media for Kasai. Na ose emanu mu 390,000 ye de aka nana adodanko akufu adode ho Ashanti region. Ene ebeda adi se eno nso na ya atro akohwie na na odi. Adentia saa asem no omanka ewo mo krata omo de beto eye court anim no. Ebiem se ne omo kase wohwe regions no ene enema ankoso ye widespread irregularities just enema abato mo ankoso ye no. Ene ye sabeto adi se omo agents eyo mo na musifo a omo wo eye regions no emu 13 edumiensa ena esign na emu bie ni ho nso a otro se na owo asemboni bi ewo ho a oka ebiem ene ne beto adi no so se agent nso anomwo National Collation Center hoi eye Rojo Metonunu ordinance hye emanu dumienu ase eye krata from 13 no ɔde ne nsa ɛhyɛ aseɛ ansa na ɔmu firi hɔ adeɛ baako ɛsa bɛtɔ adi ɛnɛ nso ne sɛ ɔpani Kwesa White sɛ ɛyɛ EC chair Madam J Mensa ɛna hyɛ ɔmo sɛ ɔmo mfiri ɛyɛ EC headquarters ɔno ɔmo ne ɔmo presidential candidate nkɔdi nkɔmɔ abusuafo asɛmwe ɛnɛ sɛ hu sɛ no nso emu ɔwrɛm na yakɔfisɛm san sɛ wo a yatetew woyɛ agent woyɛ obi anamu sini wo bɛyɛ adwuma ma obi esi den na nipa a adnano bia no ano esi ni so ɔyɛ kofini ɔnyɛ n'adwuma ye ɔyɛ obi a ɔyɛ bias na ɔka kyerɛ wo sɛ firi hɔ ne gya w'adwuma a woyɛ hɔ na wo nso wagye ne di ɛnɛ yɛ hu sɛ no nso ɛsa yɛ bosirimuka na yɛ akɔhwie ɛnɛ yɛ sɛ hu nso sɛ ɛyɛ ɔpani Kwesa White sɛ ɛyɛ ɔnoa ne ho nipa a ɔno ne yɛ adwuma mɛgya metonunu yi ɔsi krata ne bi ɔde ne nsa hyɛ ase no ɔsan wieɛ no ana anadwuma na asɛm hu sɛ sɛ wayɛ mfomsoɔ aden tire nipa wayɛ mfomsoɔ no yɛmfa ɔno Muhammad tena daka mu san sɛ ɔboa ehu kakra bi enso ɛhyɛ hɔ nom ebiem sɛ wohwɛ nkɔmɔ a ɛsa kɔɔ so ɛnɛ nso a ade baako a yɛsɛ hu yɛ ɛne sɛ moyɛ agent mienu moafa ntitiyem yɛde mo nyina mo ba bɛgyina hɔ nom ama ɛyɛ ɔmampani dada Mahama na mo se biribi twetwe mo aso a esi dan ɛna mo ka sɛ mo mienu nyinaa no mo firi hɔ na mo akɔ boapayɔ ɔmo boa saa brɛ no na ɛyɛ from 12 year free regions ɛba no emu dodoɔ na aba ama ɔmo hu sɛ ɔmo pani a ɔmo di n'akyi ɛyɛ former president Mahama no ntwo wadi nkuguo ntina ɛwɔ sɛ ɔkɔ na ade baako a ɛsa yɛ anigyeɛ ɛwɔ mmerɛm sɛ yɛ toto ɛyɛ dansini bi ano a ɛyɛ a judge from panifoɔ etimi nso busa nsɛmfoɔ no baako a ɛyɛ efiri ɔpani ɔbaapa Getu Tokuno ebusa sɛ okay from 13 wo so afa ntitiem wo ho bi pɛn ɔse an me ho bi pɛn ɛna ɔde ne dia a ekuta no ɛkyerɛ no ɔde kyerɛ no ɔse ɛnyɛ no a n'anim mmerɛnim abusua ɛno nso yɛasa kyerɛ mo sɛ ɛyɛ atrɔ kɛseɛ ɛyɛ CI 127 ebi nie sɛ okɔ ɛyɛ page 62 and 63 a ɛyɛ sample of the form 13 no ebi wɔ hɔ declaration of presidential resource form ɛnie abusuafoɔ eti ne ɔmo sa bɛgyina afidie yɛkyi sa kan yɛ sɛ ɛni mmerɛmu no ɔmo boa ɛno nso yɛ akɔhwie kɛseɛ a ɛnɛ ɛno nso ɛbɛtɔ adi na ne korakora no sɛ ɔbɛkaeɛ a ɛyɛ judge pani ɔbaapa Mariama Owusu nso busa ase nyamdi kaka na mo yɛ mienu eti ada na mo fi sɛ bibi twetwe mo aso kora baako pɛ ɛnka akyiri na ɔno hwɛ ne yɛ kɔ so ɔma anya anu yie ɛnso ama justice Yawapo ebusa sɛ okay mo dwumadi a mo di nyinaa no mo yɛ agent now do you act on the instructions of your principal and now say on the instructions of the EC na onye mo gyenche sɛ ɛyɛ nhyɛma mo sɛ ɛwɔ sɛ EC na asɛm a ɔka mo di so anaa sɛ ɛba saa deɛ na ɛka me akɔ sɛ adwuma a yɛde hyɛ wo nsa no ɛna wato ne paa hwii ɛna wagya hɔ nom akɔ ɛhɔ ɔpani Chachu kasa a ɔkaeɛ nyamea nom no kure ne mu ɔya ɛnyɛ fɛ ɛnyɛ kasa a ɛho teɛ koraa ɛtumi ka kyerɛ judge mpanimfoɔ yi sɛ they are harassing your witness very unfortunate statement ɛna ebiem Justice Mafusau ɛnso ebusae sɛ wo se wanfo wani kosua yi ɛnhu EC chair no wan instruct wan ka hwe ankyerɛw eti kwan bɛ na wo se nipa no fa so o instruct o se o ampa o media manhu EC chair no na emom ɛyɛ me colleague Rojo Metonunu ɛna ɛka kyerɛ me sɛ ɛyɛ EC sɛ yɛnkɔ na journalist ɛna mo busa asɛm a emu odu paa ɛno hɔ nam de ba bewie sɛ ɛbrɛ bia no munya kwanya bia na EC mo sopa no mo twe na bo so mo yɛ ne ho fi na esi den obi a mo ngini di na yatete mu agent mienu na yɛde mo akɔ na kachi sɛ mo nkonko gyina mu ma former president Mahama na mo mienu nya asɛ mo gya mo laptop so hɔ o konso wo se wo phone so wansa afa charger anko anadwo ma na asɛm be nie ɛna phone obi etu kwankɔ ne charger kɔ no wo de wo so kwakoda baby 2 days 3 days o kɔ refill charger etu phone adum wantimi ne nipa osma na ani nkomo mo nso a mo nyini pani ni a mo se mo mienu nyina mo kɔ na esensem no nyina no akɔ anadwo ma na asɛm enukura wo mu ni sɛ omunim sɛ omadi ntwo omadi nkuguo enti also mu pɛ bibi na omode katakata omani nyame ya adom a court ahyɛ sɛ ɔkyena ane ebehia abusuafo sɛ ne amesrɛ mo no sɛ ne adam yɛ no no mɛsrɛ apani Before I can home, General Secretary of the ruling New Patriotic Party, a year Openi John Bwedu our Waha, lawyer Nana Adwa Adobia.
Enti obobo bodin obobo wonwa a lawyer for ni nipa koja wo mo ewo eye court ho. Na said and the Supreme Court ayade Oma pejo mu ama yentem said be ya ebetimi aye adwuma no de aka ni nyina ti abusua mayenda mo ase fortunately for news for ne drive for ne ojemre na commercials na yakre eti omu ni problem bia GH Bobo News Jingle no na fei yetini
lawyer Victoria Bass
akọ news for ne kofi mu betwa so let me shout bye bye
102.9.
Premo ato apahon besima endan bia mamo nyina ha bia mo bia da so e wo Supreme Court ene ensemfo fra asi o memo ne amahoro eso